Good morning. All right, so
Morning.
good morning. So this is our second case scheduled for argument today, which is case number C210115, Laurie A. Mckenna versus Peter J. Mckenna. If attorneys can please identify themselves and their readiness to proceed.
Greg Adams for Laurie Mckenna, and I'm ready to proceed.
Good morning.
Amy Keller for Peter McKenna. I'm ready to proceed.
All righty. Attorney Adams, would you like to reserve time?
I would, 3 minutes if I may, Your Honor.
Whenever you're ready.
For ease of communication, I'm just going to refer to the parties as we did in the briefs as Peter and Laurie. Your Honors, the finality of judgments is the fundamental legal principle that's at stake in this case. The Supreme Court in Grava versus Parkman said it this way: an existing final judgment or decree between parties to litigation is conclusive as to all claims which were or might have been litigated in the first lawsuit. There are, of course, a handful of limited exceptions to the finality of judgments. One of those can occur in a domestic relations matter when a court imposes an order of spousal support. And the law does permit that type of order to be revisited in very limited circumstances. This court's case in Brendamore versus Brendamore and 310518 provide the roadmap, however, that must be followed before the court acquires jurisdiction over the case. And that's the key element here. They provide that there have to be three elements present. One, the decree, the original decree, has to retain jurisdiction, and that's not a dispute in this case. Two, there must have been a substantial change of circumstances that occurred after the final decree and prior to the motion that makes the order, the existing order, no longer reasonable and appropriate. And that substantial change must not have been taken into account by the parties or the court. We cited in the brief the Burkhardt case, which I think gets cited a lot for the proposition that the burden to establish each and every one of these elements is on the movement before the trial court can proceed. In our brief at pages 2 and 3, we provided a fairly detailed timeline to put this case into some context for the court. I'm not going to go into it here unless the court has questions. I will note that principally what was argued about in this case factually was Peter's 27 income, which he had presented evidence of both from he and his accountant during the trial, the original property trial. Also, the argument that an average of his 2015 through 27 incomes should have been used by the trial court in fashioning the original spousal support order. Again, an issue raised during the trial on objections to the trial.
Well, let me ask you this. So if in a divorce proceeding where one party says, hey, guess what? My income has been dropping over the last several years due to these various factors. And the court says, yeah, I get it. And I award a certain amount. But let's assume that the income continues to drop after the divorce decree and maybe drops even more precipitously. Even though the court did take into account the fact that the income was dropping, it has now dropped further. And is that appropriate for a court to consider as a change of circumstance?
It would be if two things happen. One, the precipitous drop represents a substantial change in circumstances from the circumstances that were in existence at the time of the decree, which no longer makes the existing award reasonable and appropriate. And in addition, that precipitous drop has to have occurred after the decree and prior to the filing of the motion. Because a spousal support order, just like every other final judgment, is a final judgment. And the only limited exception to changing it is what's provided for in Brandon in the statute, Judge.
Let me ask you, Mr. Adams. I know that statute has changed since Brendamore, and it's my recollection that the court relied on the doctor's income for 2014, 15, and 16 when it fashioned the support order. It did not have in front of it the 2017, 2018, or 2019 income for the doctor, which when you average those out, it is fairly a precipitous decline in income. So my question is the change in the statute appears to make whether the change was foreseeable irrelevant now. Do you agree with that or disagree with that?
Well, the issue that existed prior to the change in the statute was the definition of foreseeability. You had a line of cases that said anything's foreseeable and another line of cases that said it had to be specifically foreseeable. The attempt with the statute was to get around that confusion that existed in various appellate courts and to say that it had to be taken into account. That's the language of the statute. Frankly, there's not a lot of case law, if any, that I'm aware of that really talks about the meaning of that phrase, taken into account. I would interpret it to mean that it has to have been presented to the court by the parties, and the court has to have considered it. In other words, in this case, the 17 income was raised. The average income between 15 and 17 was raised. It was in objections. The court overruled the objections. So clearly the court took it into consideration, took it into account. Now, they chose not to believe it, chose not to use it. And then the other thing, Judge Winkler, I would say is that it's what Peter's doing here, and I think what the trial court did is they confused the evidence that's required to establish jurisdiction with the evidence that can then be used to determine whether or not to modify the original order. The evidence that has to be considered to acquire jurisdiction over the case is evidence of a change of circumstance, substantial change that occurred between the date of the decree and the date of the filing of the motion. So you're right. You can argue that its income in 2018 and 2019 may have been different. I don't agree with that, by the way, but regardless, it's not important because you can make that change. But that didn't occur in that window of 20 days between the date of the decree and the date he filed the motion. And that's the key to jurisdiction. The court doesn't have jurisdiction.
Let me understand that, because he did file the motion very early after the decree. But when the court actually decided it, like 2 years had passed, give or take. So what is the best authority that says the court cannot consider what happened after the filing of the motion?
Your case in Brendamore. Brendamore makes clear that the change, which gives you the authority to change a final judgment, has to have occurred. It has to be a substantial change that occurred after the decree and prior to the filing of the motion. You can't file something. It's the same thing as I could go to court today and file a motion for a personal injury when I've not had any injury occur to me. I have to wait till the injury occurs before the court has any jurisdiction to consider that issue. Same thing here. The court has no jurisdiction over the case to consider the issue until the change occurs. So what happened in 18 and 19 and 20 and 21 is irrelevant to the question of jurisdiction. It's not irrelevant.
So if the doctor, so let's say this, this proceeding languishes for a variety of reasons, and now the court's getting ready to decide it, and the doctor realizes this and files a new motion at that point, just saying, hey, by the way, these circumstances have changed. Would that cure that jurisdictional issue that you're concerned about?
I'm not clear. You mean during the pendency of the property trial itself?
No. So same facts. Let's say that the motion was initially filed 20 days, a month after the divorce decree. But then the proceedings languish for a variety of reasons. It takes 2 years to get on the judge's desk. And at that point, the doctor realizes there's a jurisdictional problem. Could he then file a new motion of change of circumstances, say, let me bring everything forward?
Yeah, I understand your question. And yes, he could. But what it would do is it ties to when the effective date of the order can be put into place. In other words, if he files it 2 years later, it's not retroactive to 2 years before that. It would only be effective from the date he filed the motion forward. So yes, with that condition.
Right.
I would simply say here, without going into much more detail, that the substantial change, fundamentally, the substantial change has to be something that occurs between the date of the decree being entered and the date of the final. Otherwise, the court doesn't have jurisdiction to proceed, doesn't have jurisdiction over the case. That's our fundamental argument in this case. And again, I think I said to Judge Winkler, the confusion I think comes up in trying to distinguish between the evidence that's required to acquire jurisdiction versus the evidence that must be available to then demonstrate the extent of the change that should occur, presuming the court first finds that there's jurisdiction. The court, I would also just summarize really quickly. I think if you look at it globally, what I think is happening here is Peter, by filing the motion to modify, instead of choosing to file the issue and raise the issue on appeal following the entry of the judgment, which he could have done and didn't do. What he's really trying to do is relitigate by motion what he chose not to do by filing an appeal. Spousal support orders, just like I said, like any final judgment, are conclusive as to all claims which may or might have been litigated in the previous lawsuit. Didn't happen here. And I think you can really ask yourself a series of questions, which I think if you answer in the affirmative demonstrates the point I'm trying to make. Was the issue of Peter's 2017 income argued in the trial court, presented and argued? Of course it was. Was the issue of using an average of his 2015 and 2017 average income argued in the trial court? Of course it was. Could the argument have about using the 2070, about the court using the 27 income been raised on appeal following the decree? Of course, it could have been. It wasn't. Could the average of the incomes between 2015 and 2017 have been argued on appeal? Of course they could have been, but they weren't. I think in the end, what is required is Peter in the trial court failed to establish any change of circumstance that occurred in that 20-day window of time between July 31st, 2018 and August 20th of 2018 when the motion was filed. The trial court.
You have about a minute left and I'll reserve your 3.
Okay. The trial court, I'm going to finish. The trial court erred in its judgment, I believe. Its judgment should be reversed and dismissed for lack of jurisdiction over the case. Thank you.
Thank you. Good morning.
Good morning. Did I just start or am I waiting for a
Whenever
cue?
you're ready.
Okay. Your Honor, the short of it is that after some confusing case law like Brendamore, the Ohio legislature added section 3105-18F1B to the statute in March of 2013. The new statute states that the change in circumstances allowing a spousal support modification must not have been taken into account as a basis for the existing award, whether or not the change in circumstances was foreseeable. The order in the Mckenna case was not made by the court. It was not an agreement between the parties like the Brendamore case was. Therefore, the only entity that took anything into an account was, when making the order, was the trial court. Now, the trial court very clearly states that it did not take husband's 2017 income into consideration when making the pre-decree order. They're the ones who made the order.
Ms. Keller, let me ask you this.
Yeah.
If my math is right, if you average the 2014 through 2016 salary and you compare it to the 2017 to 2019, it looks like the latter, there's like a 10% decline from the 2014 to 16. I guess my first question is, do you agree with that math roughly?
I don't have that math in front of me. I thought that the decline was about 100,000, which would be a little more than 10%.
Mm-hmm. Yeah, I had it at 80,000. My math could be wrong, but let me ask you this. Let's assume that it is 10%. 10% fluctuations for someone who owns a business or is a partner at a law firm is not unusual from year to year. And I guess my question is 10% enough for a substantial change in circumstance? And if we somehow were to suggest that it is, does that then open up the floodgates of challenging divorce decrees basically on an annual basis, depending on, fluctuations in income plus or minus 10%?
No, Your Honor, I don't think it is. One thing you're leaving out is Mrs. Mckenna also had substantial additional income. So it isn't just the change in husband's income. His income went down, her income went up. So I'm pretty sure the number of the total change is significantly more than 10%. But no, honestly, what keeps the floodgates down is the cost of attorney fees and litigation. I mean, if it isn't a substantial amount, you're going to spend a lot more on your attorney than you are ever going to benefit. So no, I don't think it opens the floodgates. The pre-decree trial court was required to make findings of fact sufficient to allow an appellate court to review its spousal support decision. The income of the parties is the single most important factor in a spousal support decision, and the only finding that the trial court made about husband's income was that sentence that says husband's taxable income was in the amount of $888 in 2014, $834 in 2015, $770 in 2016 for a 3-year average of $864,000. Now, the trial court stated in footnote 2 of its post-decree decision on objections, quote, Ms. Mckenna is now attempting to argue there is nothing in the record tying the magistrate's average income findings of fact to the eventual spousal support order, end quote. Because the that wasn't the end quote. The court went on to say, because the magistrate did not otherwise address Mr. Mckenna's income, Ms. Mckenna's argument is not persuasive. Now, in my opinion, clearly a 3-year average that removes the $988,000 that husband earned in 2014 and has gotten nowhere near since, and substitute his income of $777,000 in 2017, which was extremely consistent with his 18 and 19 income. That's a reduction of over 210 in annual income there between 14 and 17. We believe that's clearly a substantial change in circumstances. Now, Mr. Adams's big claim is that the substantial change of circumstances must occur between the date of the decree and the filing of the new motion. It is my belief that Mr. Adams has taken a mere statement of fact in the Brendamore case and is now attempting to convert it into a legal requirement. Just because the Brendamore court stated that Mr. Brendamore did not show a change of circumstances during that time period does not make that a requirement in all cases. It was not even a requirement in the Brendamore case, and it is not what the Brendamore case was decided on. The Brendamore case was actually decided on the fact that Mr. Brendamore did not introduce into evidence what he and his wife had taken into account, that's the requirement, when they agreed upon the spousal support order. His argument in Brendamore was that his income had been trending down before they reached the agreement, but that he didn't know it because she had kept some information from him. But he didn't present a good case. He didn't present to the court, this is the information that we based it on, and this is how it's different.
Well, I guess my concern too, Ms. Keller, on the facts of this case is the motion was filed so closely after the decree. And I think like your argument is essentially, well, it was vindicated by subsequent events, but then that kind of forces parties to litigate, and maybe it turns out it is vindicated, maybe it turns out it isn't. But, again, that just seems to invite a bunch of unnecessary litigation.
I can certainly explain that, Your Honor. And that is, the crucial thing was the 2017 income. My client obviously knew that his income was substantially down, that 988 figure in the average that was raising everything up just wasn't obtainable by him anymore. As you saw, we did the best that we could to try to get that considered. But I believe we had 2 days of trial in October, and then we had a 3rd day of trial in early January. And I think our last day of trial was January 18th. I think you all are aware that income information dribbles in and is supposed to be sent out by January 31st. And most business tax returns, a lot of them aren't completed until like October of the year. So we took the information that we had, which was clearly not accurate enough, and we presented it. And Mr. Adams is the one, if you look at his written argument to the court, pre-decree, he kept calling it preliminary 2017 income, preliminary 2017 income. So the court therefore did not consider that. I filed an objection about the fact that the court didn't consider it, and the court overruled that objection. And I completely understood why, because the tax return at the time of the hearing wasn't out yet. Clearly, as we saw, there was a big difference in the number between the preliminary numbers and the tax returns. So the court was absolutely right in not considering that. Plus, you have to consider in this case, Mr. Adams hires an expert who spends months going over everything in my client's tax returns. She spent at least 4 months. She asks him for every single backup piece of information. There is no way that I could have popped up after the hearing, shown up at a 45-minute objection hearing in front of Judge Stevie, and said, voila, suddenly we have his tax return. It just, Mr. Adams would have said, objection, my expert needs to look at that. We haven't had a chance to cross-examine that. So the reason that when I got that decision from the judge, I read it as, oh, I get it. This is a motion to modify. This is not an objection. So I had to wait until, I still couldn't do it then. I had to wait for the decree to go on. And then I filed it relatively quickly so that we could address the 2017 income information. But if you consider what Mr. Adams is asking here, you would never, ever, ever get a divorce done, because in a case like this, early for getting a tax return for a business is in April. Then he would hire his expert. Then his expert would take months to review it. We might be lucky.
Well, but I'm also concerned from your perspective about never getting a divorce done. That every time there is kind of nominal changes in circumstances, parties are going to go back to litigate, and the notion that it's not cost effective for them. I think you guys deal with this much more than I do, but I've seen a lot of divorce-related litigation that's not necessarily cost effective because there's a lot of emotions involved, and people are continuing to want to relitigate battles that should have been, settled by now.
Respectfully, Your Honor, I disagree. Spousal support is about the money. It's about the numbers. Clients don't want to spend more modifying it than they do in the trial. The cases that just come back and back are parenting, because you can't put a dollar figure on that. And also, you don't really see that. I've done nothing but divorce for 27 years. I've never seen a case that just comes back year after year after year on spousal support, because once you figure out what the court is going to do, you're like, okay, here's the new information. And, the parties then at that point, okay, well, this is how the court looked at that, boom, and you put an agreed entry on. But to say it was obviously the court considered it to be a dramatic decrease in income. So to say that can't be considered is just absolutely not how courts should be proceeding. I mean, the information has to be considered. And I can tell you, divorcing people who own businesses always say business is down. I mean, you go to seminars with magistrates, they're like, yep, nothing worse for a business than a divorce. Every time you get divorced, business is going down. So to say that when my client came in and said, oh, business is going down, competition is up, the court considered that? No. Divorce courts say, wait and see. We're not going to guess. Wait and see. They always say that. Divorce courts have to deal with a situation as it exists. And then if there is a significant change, which unfortunately it was kind of right in that 17 year. And the biggest reason was because they took a 3-year average, which is very normal for a business because income varies. But it was that last year, the big change is really between 14 and 17, anyway, moving on. Your Honor, even if the Brendamore case had found in its case that litigants were required to show a change between the date of the decree and the filing of a post-decree motion, which I absolutely disagree with. If you fully read the case, that's not at all what it says. It still wouldn't be relevant because that case was decided in 2012, which is prior to the change in the statute. I already covered that. Mr. Adams said that this is important. This is a final judgment. That's really not the case here because the court clearly left continuing jurisdiction. And that is why courts leave continuing jurisdiction over this situation is circumstances can vary a lot and the court needs the ability to go in and make a modification, when it is appropriate. And even in the law that Mr. Adams cited, he said a final judgment for anything that was tried or could have been tried. And for the reasons that I just talked about, it could not have been tried. The tax return was not ready in time for the trial. And both pre-decree and post-decree, Mr. Adams hired an expert who was crazy slow and just took months and months and months to review everything. Again, Mr. Adams keeps saying considered. It's not considered, it's taken into account. And the court was clear they did not take it into account. And there was talk about filing a new motion, which is a perfect example of what happened. Because my client did, in fact, file a new motion. Because when we came back to trial, COVID had hit. My client is a doctor. He got shut down completely. So we did at that point, we talked, I can't remember the exact procedure, but we talked about that. I think the magistrate said, well, Mr. Adams said, well, that's a brand new thing. We're not ready to address that, which happened in 20. And you need to file a new motion. So we did file a new motion, and then that got set for a report to begin a whole new discovery process. So again, you can't just try everything that happened up to that date. You have to go through a very laborious discovery process. I mean, it's in a big case like this, it would be it's unusual to go from motion to decision in less than a year with all of the discovery and the magistrate's decision and the 14-day objection period. And then you wait a couple months to get a transcript, and then you have the argument in front of the judge, and then you get in another month, you get the decision. Mr. Adams is implying we should have appealed the 2017 not being considered. Well, we didn't appeal it because we think the judge's decision was absolutely correct. For practical reasons, you couldn't consider 2017 income at that time. What the appropriate method was to file a motion to modify, which is what we did.
Attorney Keller, you have about a minute left.
Thank you. And I'm done.
Okay. Attorney Adams, you have your 3 minutes.
Thank you.
I'd like for you to address this for me. How is it that the 2017 income was taken into account?
Well, the party, remember the statute says the parties or the court. In other words, that's what the statute says. It doesn't require the court to take it into account necessarily, as long as the parties took it into account. Well, I think the court did as well for two reasons. One, it was raised in the trial court during the original proceeding. It was objected to and overruled by the trial court after significant argument with the transcript in front of the court. So clearly the court took it into account in overruling the motion. I've got to presume they took it into account. And then secondly, certainly Peter took it into account because he went to the trouble of not only testifying himself, but also having his accountant come in and testify. So he clearly took it into account and presented it to the court. The court simply rejected the notion. Now, does that answer the question, Judge? Because I had a couple of other comments.
I guess what you're saying from the court's perspective is that because they decided it wasn't relevant, it was taken into account.
You're nowhere going to find in the record anywhere where the trial court said we didn't take it into account, nor are you going to find anything in the record that says, nor do we think it's irrelevant. You're not going to find that. They say that, but that's not what happened. They presented the evidence. The court simply chose to not put it into its. It chose not to take it to use 2017. That's simply the fact. They didn't reject or accept or anything or find anything irrelevant. They simply, the evidence was in. How else can the court take something into account if the evidence has been put in and the parties make the argument? What's the court required to do? Reject it, each detailed piece of evidence, say, well, we reject this piece of evidence? I don't think so. That's not the way the trial court works. Just a couple really quick things. One, the question was raised about the 10% decline in the income. And Ms. Keller made the point that its income is the single most important factor. That's simply not true. And you'll not find that in the statute. You'll not find it in any case law. There are 14 separate factors the court is required to consider, income being only one of them. The court does not use a formula. This court has never used a formula. In fact, this specific trial court, this judge has specifically said, I would never use a formula. I think it's inappropriate. It's not a formulaic approach he uses. And the last thing I would make is this income, this 2017 income issue is really at the core of this. The reality is that in January of 2017, during the course, or 2018 rather, Peter offered not only his testimony, but also the testimony of his accountant as to a level of income, which proved to simply not be anywhere close to being accurate. He then prepares and completes his 2017 tax return and files it with the IRS. The next month, in May, he files objections. And in his objections, he refers to the old income, the $670,000 versus the $777,000 that was actually in his tax return. He doesn't mention that to the court. He doesn't bring it up in his objections. He doesn't bring it up in his argument, and he doesn't ask the court to take it into consideration. So, and then he comes back and tries to argue that, well, after the fact, I now know what my income actually was, and so therefore I can now raise that as an issue on a motion to modify. I simply disagree with that. The last thing, the question was raised about could you file a motion the next day, and then later, and then rely upon subsequent events to create jurisdiction? And I think the answer is clearly no. And Brenda Moore addressed that basic question. I don't agree with Ms. Keller that it was just simply a statement of fact. It's a part of the court's reasoning behind its legal decision. This court said nothing had changed, quote, between when the decree was entered and when he filed his motion to modify the support order. That's really the key to jurisdiction. What substantial change has occurred that gives me the right to go back and reopen this litigation? And if I can't demonstrate it by the time I found that it existed when I filed my motion, I don't have a case. I got to wait till it happens before I've got a case. Thank you.
Thank you. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision, and we wish you both a wonderful afternoon.
Thank you.
Thank you. Good morning.
Good morning.
Welcome to the First District Court of Appeals. This is our third and final argument set for this morning. This is case number C210002, State of Ohio versus Lyndon Sperling. Mr. Sperling, you are the one that filed the appeal this morning.
Yes.
Okay. And Attorney Paula Adams, you're representing the state of Ohio, and you're ready to proceed?
Yes, Your Honor.
Okay. Mr. Sperling, you have 15 minutes to present your case this morning. Of those 15 minutes, you can reserve any amount of the 15 minutes to respond to Attorney Adams' argument. Would you like to reserve some of your 15 minutes?
Yes, I'd like to reserve maybe 5 minutes.
5 minutes. Okay, so that gives you 10 minutes for your argument, and then 5 minutes to respond to Attorney Adams's argument. Okay?
Okay.
All right. We'll begin whenever you're ready.
Okay. I'm sorry, which part here? This here? Okay. So I filed with the court, as you know, a motion to vacate for lack of jurisdiction and notice of the charge. And they recast the motion from I cited the rule on their motion, and apparently the court rejected this motion, alleging that it was a post-conviction petition, and And basically what I'm presenting to the court is that due process was violated in this procedure, where apparently the state came with charges in the indictment, and the charges for which I was, the offenses for which I was charged was a trafficking offense and a possession offense back in 2005. And what happened was that my lawyer, he failed to inform me that based upon the amendment in the courtroom, he failed to inform me that they was going to include additional elements in this process. So what I'm trying to get taken care of at this present moment is whether or not due process was violated in the court. I was charged with 1 count of trafficking in cocaine under revised code 292503, and it says that the Don Sperling knowingly prepared for shipment, shipped, transported, delivered, prepared for distribution, or distributed a Schedule II controlled substance, to wit, crack cocaine, in the amount that equal or exceeded 1 gram, but was less than 5 grams. That was in the first count. And then in count 2, I was charged with possession of cocaine. That charge read, Don Sperling did knowingly obtain, possess, or use a Schedule II controlled substance, 2 wit, crack cocaine, in the amount that equal or exceeded 1 gram, but was less than 5 grams. As written, that charge was for felony 4 under revised code 2925.11C4B. So the essential elements in there where it states that I have possessed what equal or exceeded 1 gram, but was less than 5 grams, was altered.
Mr. Sperling, can I ask you a question? You filed a 2019 motion to vacate for void judgment, and then we ruled on that in 2020, and then you filed your 2020 motion to vacate for void judgment. So how do those two motions differ?
I'm actually being more specific in this motion in terms of how they violated my due process rights, and with me challenging the jurisdiction. I wanted to point out that let me situate it here. What happened different is that I'm challenging jurisdiction and the fact that they violated my due process rights in this particular motion. The last motion, I just alleged that they violated, or that the court lacked subject matter jurisdiction without specifying specifically what it was where they lost subject matter jurisdiction. Well, what I'm here for now, this motion is different, particularly because I'm arguing due process. I'm focusing more on due process violation under the 5th Amendment, because I had a right to a grand jury indictment.
Mr. Sperling, your argument with regard to due process that you're saying that you're presenting it now with the new motion, is that something that could have been presented previously?
Well, at that time, I was oblivious to the information. I did not know exactly what it was that I needed to argue in the previous petitions that I filed with the court. And so I got better over time, and I construed that the elements for which they amended were not included nor among the elements for which I was indicted on. And so that's what brings me back with being more specific about the due process violation, particularly because the judge, instead of him being neutral to the situation, he should have stopped me at some point and asked me if I knowingly entered into this plea, with the exception of my lawyer that never explained to me that I had a right to grand jury indictment, and that for them to make such amendment, that it would have to be resubmitted back to the grand jury in order for them not to lose, lose their way with the proceeding. So, let me see here. Basically, what I'm arguing here is that the amendment and indictment was void because the elements for such offense were not present and were not included amongst the offenses charged in the indictment. And it says right here, let me get right there. In Watson versus Jago, 558 Federal Second 330, it says in head note 1, under the Fifth Amendment provisions that no person shall be held to answer for capital crimes unless on indictment by a grand jury. It has been the rule that after an indictment has been returned, its charges may not be broadened except by a grand jury. And they reference to State versus Strong versus United States. And the citation for that is 361 US 212. And so when my lawyer brought forth this amendment, what have you, he never did explain to me that I had a right to grand jury indictment. So I was oblivious and I was unconscionable when they brought forth the amendment of the indictment, because at the time I did not know that I had these rights and that these rights should have been preserved. In fact, the grand jury, the process for the due process was a prerequisite before I even got charged, right? And so how I'm looking at this is, with the exception that I was unconscionable, the judge, the lawyer, my lawyer, and the prosecutor, they knew that they did not have the discretion to amend the indictment in the manner that they did. And so that deprived me of due process, particularly because now I'm denied notice of the nature of the charge, or I was provided notice of the nature of the charges, but when they came forth with a different charge or offense, you know, now due process is validated because I had a right for that amended charge to go back before a grand jury in order for them to determine the facts in which offense I should be charged with, and or if that was a lesser included offense. And in this case,
Now, the amended charge was something that ultimately, it was like an agreed plea. Am I understanding that correctly?
well, have I mentioned that? Is that what you asked? I'm sorry.
No, just from the record, that's what I understood.
Okay, so from the record, yes, the state is arguing that it was an agreed sentence, but even still, there's nothing.
What I was talking as far as wasn't there, you originally were facing 2 charges.
Yes,
And then there was a plea taken on 1 charge,
yes,
and that was a different charge than any of the 2 charges that were the original.
yes, correct.
Okay. When you took that plea, were you aware that it was being amended to 2 charges,
Well, I
from
didn't.
2 charges to 1?
No, at the time when I took that plea, my lawyer, he didn't explain to me whatsoever. All he explained to me is the judge wanted to do, he wants to see you do 6 months more. Actually, if you look at the plea agreement, I played out to what I thought was the 4th. At the time, I do remember this like yesterday. I was under the impression that I was pleading out to the 4th degree possession of drug. If you look at the plea agreement, they went behind and altered, scribbled over where I already agreed to and made it reflect like a 3rd degree possession. And then I stood before the judge, not knowing that any of this was going on, only for the state to represent to the court that I possessed what exceeded 5 grams, but was less than 10 grams. And when the prosecutor presented that to the court, I did not even know how to defend that. I just knew that those were the facts because that's not what I possessed. I didn't possess 5 grams or more. So I did not know how to defend. At that time, I went to go, after they got the conviction, I went to start picking up books to understand what took place. And it took me literally all the way up until just recently to construe what took place in that courtroom. So yes, I was oblivious to what was going on and unconscionable upon the decision making that I was left with.
Thank you for your response. You're at your 10 minutes. I'm going to reserve your 5 minutes, okay?
Okay.
Okay, Attorney Adams.
Your Honors, actually, unless the court has any specific questions, I'm prepared to submit on my brief.
Okay. I guess one of the questions I'd like for you to respond to is that there were 2 charges and then there was a plea to 1 charge. And Mr. Sperling, one of his arguments is that it needed to go to the grand jury and for there to be a re-indictment. Can you address that argument, please?
Well, based upon what's available in the record now, I don't believe that there's been any, I don't see any post-conviction petitions in the history of this case that would have offered any other information to support that. So I think based on the record that's before the court, and there wasn't, I'm trying to see if the record indicates a direct appeal. It's just that this was a plea down from dismissal of count 2, which was the trafficking, and then a modified count 2 to the possession. And that was an agreed, sorry, my light went out. That was an agreed plea involved in that to the 2 years. So that's what's contained in the record. Aside from that, the state doesn't have anything to offer in response to that.
Okay, and maybe I wasn't clear in my question. Okay, so I'm gonna try to phrase it a little differently. So Mr. Sperling's argument is that with this plea, with this agreed plea, that it could not have been done absent a re-indictment, a return to the grand jury.
No, the state obviously wouldn't agree with that. I mean, this was all, transpired on the record before the trial court, and that's all the info. I, can't speak to what Mr. Sperling obviously was present and, what transpired between him and his attorney. So based upon the information and that's available in the record, I do not believe that the matter needed to be re-indicted.
Okay, thank you. And unless there's any other questions from the panel? Okay, thank you. Mr. Sperling, you have your 5 minutes.
Okay, so she was saying count 2 was, I believe she said count 2 was possession. Count 1 was trafficking. Well, on the count 2 part, it was initially, like I said, on count 2 offense that I was charged with, possession, that's what I initially possessed. That's what caused me to also be charged with trafficking, because
I think just for clarity, as I understand it, count 1 originally was a felony 3 trafficking in the vicinity of a school or juvenile. Count 2 was a felony 4 possession.
Exactly.
Okay.
So I was charged with the trafficking because it was alleged that I possessed the drug within the school zone. So when we get to court, like I said, they amended the indictment that included additional elements that were not found by the grand jury, the 5 to 10 grams from 1 to 5 grams. And so that's what I'm disputing here today, is due process that was violated, because I was not made aware of this back through lawyer, and neither did the judge do a full criminal rule 11 hearing with me to determine whether or not I entered into this plea knowingly. So regardless whether it was the first offense, count 1 or count 2, the elements changed for both offenses because they included additional elements. And what I want to say about the count 2 is, at that time, when I was charged with that offense, I know that I was looking at a total of like 18 months. And it was explained to me that my lawyer, it was explained to me via through my lawyer that the judge wanted me to do 6 months more. That's how he ever explained. But there was no reason for them to enhance the 4th degree possession of drug to reflect a 3rd degree possession of drug. And so that's where I'm pretty much at, because I don't think that, well, I know that now that I know, but I don't believe that a state can ever enhance a degree of felony by degree versus a penalty. The degree or penalty of offense, that the state can't do that. Let me see here. It says right here in State versus White, the court noted that no case directly supports the state's argument that an indictment may be amended to a higher degree charge as part of the plea bargain process. But if you look at the facts of what's going on with the indictment and what I actually played out to, you will see that the offense has been amended to reflect a higher degree. And like I was saying earlier, that's the only thing that I'm disputing here, is that no one ever put me on notice and or explained to me that this would have been resubmitted to the grand jury in order for them to come forth with an offense that's going to cause me to do 6 months more for a drug that only carried it up to no more than 18 months. So that's where I'm really standing right now, is due process violation. I was denied procedural due process on the strength that the state failed to adhere to grand jury requisites. Also, I was denied substantive due process, particularly because I wasn't given the opportunity to be heard, to present evidence and or to confront my accusers, which were the police, to say, okay, you know, how much drugs were found on my possession, you know what I'm saying? So like all these things wasn't explained to me, and pretty much particularly because I was provided with ineffective assistance of counsel. So for right now, that's what I have to go on for right now.
Okay, understood. Thank you, Mr. Sperling and Attorney Adams, for your arguments this morning. We will take the matter under submission and issue a timely decision, and we wish you both a wonderful afternoon. And this concludes our arguments for